Okay, sir.
Measure 91 allows for one person to own all four of the licenses. As you were talking about with that help too, did you have that in mind to help control the price? Because like make it more affordable, it's one of the people all steps of the process, as well as there's a lot of talk about marijuana here, but the law also allows somebody to grow hemp, wood, the licenses also allow those provisions to for somebody to grow hemp, or would that be something?
Do you want to repeat the question?
No, go ahead.
Okay, so the question was, in the marijuana side, one particular person, whether that's probably a corporation or an entity or something like that, but somebody can be what we call vertically integrated. So the same person can be a producer, can be a processor, can be a retailer. And then the same question with industrial hemp. So on the marijuana side, yes, it was clearly intentional that we did that. The current Liquor Act has a three-tiered system. It's called Tied House Prohibitions. It dates back to literally the 1930s and when Prohibition was repealed. And a particular structure has existed for 80 years. And there are some, I suppose reasonable people might disagree as to whether that system still makes sense today. But we thought, starting fresh, that we erred on the side of it not making sense. We also thought that it was a more efficient way to, frankly, do business. And in line with our kind of incentivizing businesses to participate in the system and to make it, in a way, what I would call business friendly. I know that sometimes comes off as sounding big marijuana, but you wouldn't believe, unless you're in industry, the things that these folks in industry have to deal with on a daily basis. I mean, with unfavorable tax provisions from the federal government, from the federal government's position on any number of issues, it's not easy, and sometimes penciling out a business plan is really questionable. And so we thought that, it was intentional to just give these folks, it's free enterprise. As far as hemp goes, I mean, Steve, I don't think you regulate. You're not in the hemp business, right? I mean, you're in the marijuana business. So under hemp, there's not even any. There's nothing that would restrict somebody from owning that.
So we very much wanted to regulate marijuana the same way Oregon regulates our microbrewery and winery industries. I think the majority of people now view our microbrewery and winery industries as something of pride, and that the cannabis industry can follow really in those footsteps. And McMiniman's, Rogue Brewery, they brew their own beer. They have a brewery, they sell it right there. And so we wanted to provide flexibility for businesses if they wanted to. They're not forced to be vertically integrated, but if they want to do that, we thought it made sense to have them to have the possibility to do that. And hemp will be regulated by the Department of Agriculture. And hemp was actually kind of technically, unofficially legal in the 2009 legislative session. But the Department of Agriculture has not issued any hemp licenses or started that procedure. With the change of federal government policy, they're starting to move in that direction. One thing that Measure 91 did was remove barriers to relying upon federal law. So we'll see the Department of Agriculture on a separate track start regulating and legalizing industrial hemp.
Okay. Yeah, so we're going to have my colleague Chris pass you a mic.
Are there opportunities for citizens to be involved in the decision-making process, particularly with regard to presenting stuff to the legislature?
So I'm certain there will be. I understand the legislature, and I think they announced that they are actually going to form a special committee on this issue. So they'll be holding a variety of hearings on specific legislation, perhaps it's offered there. So there will be an opportunity in the legislature. There will also be an opportunity in front of our commission as we develop rules to implement that. Yeah, go to our website. It is marijuana.oregon.gov, and that'll get you cross-referenced across all the information. We'll keep you informed through that.
Okay, sir, in the front.
It's my understanding that hard liquor, though, goes from the liquor manufacturers to the OLCC warehousing system, then back out to the local retailers. And is that the sort of system, or a system more under the beer and wine, where the retailers can actually be selling their own locally manufactured product?
So it is true that, this act, they pattern control around the OLCC. There is some differences there, and you described exactly distilled spirits, right? We take it from the manufacturer, it goes to our warehouse, we set the price, we buy it, we own the inventory that we put in our stores around the state, we set the price, and then get the difference. So that's a much different controlled system. With beer and wine large, it does go from a manufacturer to wholesale or to retail distribution. But there are, for small quantity producers, and we've carved out a niche in Oregon where you can have this relationship between what we would call different tiers or different license types. So we've knitted together some of that on the smaller scale side of the operations. But it is different. I think they did a good job sort of carving the line between giving us the opportunity to regulate it like alcohol, but it's not one for one specifically the same.
Yeah, and just to add to that, I mean, I don't think the state would want to be in the business of selling marijuana right now. It's still against federal law, so.
One more question here, trying to move over to the room, but man in white shirt. Start.
As we've discussed tonight, there's legislators and special interest groups, the League of Oregon Cities in particular, who have started to discuss about how they would really like to have the legislature make changes to Measure 91. A lot of those special interest groups have lobbyists. They're very well organized. Could Dave and Anthony speak to what are your thoughts, your impressions of how the industry is organized in Oregon, if at all, and prepared to advocate on behalf of the marijuana industry so that the law doesn't get changed in a way that really kind of goes against the will of the voters, the intent of what you work so hard to do?
Great question. It's imperative that people in the industry, concerned citizens of all realms, to stay active, stay engaged, stay vigilant. Go to the OLCC's website. I'll plug New Approach Oregon as definitely being a website to go to and stay involved to monitor this as it moves forward. And I think most importantly, we have seen the voters speak on this issue, and while the voters had in mind, I think, a general concept of this measure, and it's very important that the 56% of Oregon voters that voted for this measure, that they have their will met. And I think that just want to stay engaged, stay vigilant, and there will be many opportunities to be involved at the legislature during the rulemaking process to make sure that our voices are definitely heard.
I agree with that. I think the industry has matured naturally. I mean, having years of regulated medical marijuana has produced, I think, in a good way, an industry that is very incentivized to see things go correctly and smoothly. And lobbyists have been hired, and groups have been formed. And so I think there'll be groups who will make sure that it doesn't get derailed.
Sorry about this, it's very awkward.
Yes, good evening. Nothing was covered that I saw anyway about seed production, processing, and retail sales. Considering that it's going to be, you can do homegrown, maybe some of those people want to get some seeds to grow with.
So seeds not being considered usable marijuana, I think as far as a kind of advocate's position for criminal law, I think over years that has made sense. But now that we're moving into a regulated system, both on the medical side and for adults over the age of 21, I think there may need to be a legislative fix about seeds and allowing for the production and sale of seeds. I think the OLCC may have their own interpretation of the law. I think Oregon Health Authority legal counsel has its own interpretation of the law, and I think right now seeds may be existing in kind of legal limbo as to what they're considered. So I think with immature plants being for sale, and I think it doesn't make sense not to have seeds for sale, but I think it's possible that that's something, if it isn't handled through rulemaking, that may be something we need to address legislatively.
Next question.
I'll head back over there to the.
Good evening. So my question revolves around the different regulations municipalities will make, and so I have a couple different themes. One, I know in Washington, a lot of the cities and counties really had no idea what anyone else was doing. They didn't know how to really start this process, and so I'm wondering if there's a way that cities and counties can collaborate, share information here in Oregon, learn from each other as they're, going about this new territory. And two, if there's any type of system in place to figure out what different regulations on a local level how they actually affect the businesses. Thank you.
So I'll field that. So the League of Oregon Cities and the Association of Oregon Counties have staff that are maybe different than other states. We actually have a very aggressive education campaign with our members, and we share information fairly regularly among members. I think the extent of, as Anthony mentioned, Measure 91 allows cities and counties to regulate reasonable time, place, and manner restrictions based on the nuisance aspects of any of these retail marijuana businesses. But I think to the extent that any cities or counties engage in that will largely be dependent upon the regulatory regime that OLCC creates. So basically cities and counties in many cases have to fill vacuums left by the state legislature. I don't think Dave left a vacuum, assuming his shop fills it. So it could be that we see very few, if any, local regulations of time, place, and manner if his regulations effectively cover that. And he has authority to do that. So I guess I'm cautiously optimistic that there won't be a whole lot of regulations to share among cities or counties because he's fulfilled his complete mission. We won't have anything left to do. But we do have a mechanism for sharing that fairly broadly and efficiently and quickly in Oregon, unlike other states.
Are those organizations going to continue to advocate the local control power as means to effectuate the municipality's bigotry and banning and contravention of statewide laws, Rob?
I appreciate a softball question, Lee. I really do.
No, actually, one thing Dave didn't mention is that when we drafted the tax structure, it actually benefits municipalities to opt in. And so it's a disincentive to opt out.
So what Lee's referring to is that so the first biennial cycle up to July 1st of 2017, what happens is 10% of net after he takes out his costs goes to counties and 10% goes to cities to support enforcement of Measure 91, because in addition to the pricing, you need law enforcement to help drive out the organized black market. So you have to have those two things working together. So there's 10% of net funneled in that manner. And what Lee's referring to is that the first biennium is based on population, which always is really challenging because sometimes it pushes money to where it doesn't need to be. And then after that, it's based on the number of licensees you have in your jurisdiction. So that's the incentive to not opt out. In terms of whether or not counties and cities will continue to push for local control, I can guarantee you that we will always push for local control because, again, I can't speak for cities, I speak for counties. We believe the best government is the government that is closest to the people, and that the further away you get from the people, power, influence, and money distort proportionally.
And I guess I would say that, again, our common enemy is the illegal market that we want to diminish, and to have a cohesive policy that addresses that, I think is best done in one place.
And I just want to address Lee brought up kind of discrimination against medical cannabis patients and people that use cannabis. I think over time, you're going to see that kind of discrimination and bigotry go away, because now you're no longer viewed as being a criminal. And over time, that basically that equality and non-discrimination against a certain class of people based upon the medicine they choose or intoxicant they choose, that eventually is going to fade away. And I think that when you have 14 counties and more votes for legalization than you had for the governor or the senator, I think that really brings people out of the closet and really raises people's awareness that this is something whose time has come, and it's no longer acceptable to discriminate against people for choosing cannabis.
Hi, Greg Brunty, microbialgardens.blogspot.com. It's in my opinion, that the cities would not have anything to regulate if they did not have a budget to regulate with. And the asking for local taxes is actually them asking for a reason to regulate locally, which the state was actually charged with through Measure 91. My question is like, can taxes that have been used, like hiked up, like perhaps like Fairview with the 40% sales tax, could they conceivably drive away prospective, if they were grandfathered in, drive away prospective businesses until about a year or two when things cool down, that maybe through a quorum on city council they pass 35-cent sales tax break to a crony? If that could be, if this is why we want to keep our local taxes out and with the state.
I mean, that's why we drafted it that way, because we don't want cities doing this. It disrupts the state policy, and frankly, I don't know what the city-to-city relations would be, but if your next door city is imposing some crazy high-end tax, is the next city over going to think that, well, you're just pushing them into my jurisdiction, and you're going to end up with these situations where you have retail establishments right on the border of one city to other city. You're creating an environment where there's going to be a bunch of jockeying going on, and people are going to just do things that are not conducive to a unified policy of eliminating the illegal market. I keep saying that, but I think everyone should keep remembering that.
Yeah, I think the local taxes ultimately are going to go against not only the will of the voters, but also the priorities of the state. Not only the priorities of the state, but the priorities of the federal government. Fairview is allowed to have a 40% tax. That's only going to encourage unregulated sales, and it's also really an end around against the opt-out procedure that's laid out in front of them. If a 40% tax is grandfathered in, then what prevents them from raising it to 1,000% tax to make sure that no business operates, or cut a tax break later for a crony, like I said. So I think it's really imperative to have a uniform policy to allow the will of the voters to be implemented, but also to meet the priorities of the state and the federal government, that we bring marijuana out from the shadows into a regulated system.
I mean, there will come a day when the illegal market is of no practical consequence anymore, right? Like alcohol. There will come that day. And maybe then there's time, I mean, things can be done. But right now, you're at the very beginning of this really interesting transition. And I think we should err on the side of assisting with that transition.
Hi, I'd like to thank you guys for being here. My question is, I'm a medical card holder, and I medicate a lot of times a day. What you guys don't address is the people that take pills, narcotic pills, and they drive a vehicle. Are they under the influence, even though it's prescribed by their doctor? I got a car. I use cannabis. Does that make me illegal to drive because I medicate all day? Because if I don't medicate, I can't walk or function. So who's going to be the one to determine if I am high or not? Because when I smoke, it's not really making me feel high. And I feel fit to be able to do any job that I've ever done. So who's going to be the one to determine if I'm high when I'm driving? And what's going to be the limit of it? So am I going to be able to smoke one joint a day and you can take my license away because I'm high? and I'm not going to be able to qualify for a license because I'm on it. It's going to be the same thing with the recreational use. If you're driving your car and you're high, who's going to determine the limits? How are you going to determine the limits? Are you going to do it by blood, by eye movement, by the muscles, or how are you going to determine it? Who's going to determine it?
So you had a lot in there. I'll touch on pieces of it from a former DA's perspective, but maybe you want to address the 91 issue.
Maybe you want to give the disclaimer again.
Yeah. So, let me give you a disclaimer again for all three of us. We're going to express some opinions that are based on Oregon laws that exist today and as it's unfolding under Measure 91. You are not entitled to rely on anything that Anthony, Dave, or I says in the next 5 minutes about this topic. Great question.
Yeah, under, today, driving under the influence, driving impaired, I believe impaired to a perceptible degree of marijuana or Oxycontin or NyQuil or alcohol is illegal today. And so, and once again, consult with an attorney, your own attorney, before you rely on advice. But, basically driving under the influence of intoxicants is illegal today, and it'll be illegal under Measure 91. But Measure 91 does not set any blood test limit as far as and for what's impairment under the law. So there is no 0.08 for marijuana, like there is the blood alcohol content for alcohol. There is no limit like that under Measure 91. Measure 91 does task the state to study the issue, but I expect that if the state really examines the issue, follows the evidence actually on the ground and monitors, highway fatalities and accidents, a number of DUIs, once again, we'll see that the sky doesn't fall and that current law is satisfactory as far as making sure that people are not driving impaired under marijuana or any other intoxicant.
I think that was great. I would just amplify the standard in Oregon law doesn't change, as Anthony mentioned, for whether someone's on Oxycontin or marijuana or alcohol. The legal standard is you commit the offense of driving under the influence of intoxicants if you're operating a motor vehicle and you are affected. Your mental or physical faculties are affected to a noticeable, perceptible degree. The .08 standard we have enshrined in Oregon law is really just a presumption. So someone who tests above .08, the law presumes they are affected to a noticeable or perceptible degree. But they can take it to a jury and say, hey, at .14, I'm really not affected. And then I know people that are affected at .001. They look at it and they're impaired, right? So it's just reality. And I think I know people that have that same impact for marijuana. Some people are impaired quickly, other people are impaired not so quickly. So as Anthony mentioned, Measure 91 doesn't purport to establish a blood alcohol concentration of THC, for example. It doesn't purport to do that, but it does direct this guy in his shop to study it to see if we can come up with a presumptive impairment level for marijuana. Whether the science supports it or not, or whether he could find science to support it, remains to be seen. Washington picked one out for their measure, but unless these guys have evidence to the contrary, I don't think it's science-based. I think it's a random number they pulled out.
That was real politics.
I just want to add that, right now, we do have the responsibility under the ballot measure to do the report to the legislature. It's not exactly OLCC's forte to establish legal standards around this. We will be working to bring in others that do understand the legal standards, the science around it, to help us delineate what a recommendation of the legislature might look like. I will say that we are already putting in statewide and thinking about it. I'm going to work with our local public safety partners to make sure that we track incidents of DUI before implementation of the ballot measure and then after, so we can actually sort of see by empirically if there's changes that are coming. I'm sure that everyone expected that was, and it was in Colorado, that we're clearly looking for those driving standards, and some that we want to make sure that the public is able to see and react to and put us in a position to respond to from a regulatory or legislative point of view, probably more legislatively here, because we wouldn't have the ability to change that standard of the commission. We would just be studying it and making recommendations to the legislature.
Well, my point is, everybody that smokes recreational is going to have it in their system. So if they get pulled over and the cop thinks they're high and they're not, they haven't smoked it in 8 hours, but it's still in their system, and the cops say, well, we're going to do your blood test, and you show it up in your system, well, we're going to convict you. So what are they going to do about that?
That's exactly why I think looking at the science around this will help delineate and go exactly to deciding that problem. I think when Rob said they picked an arbitrary blood standard is in Washington, maybe to prove you there, is it. You know, they look at the physical test today, just like they do for anyone else who's impaired under another legal drug. And that's the way it operates today, and that's how it will continue to operate when this legislature makes changes.
Yeah, and once again, you want to consult with your own attorney, but just having marijuana in your system does not make you automatically guilty of a DUI in Oregon.
But if you're in an accident and somebody's harmed you,
I don't think automatically.
Give us a next question.
This is in regard to the nuisance and licensing. First off, there was a situation in the OMMP where we had people with licenses for operations had to get closed down because there were too many in the local area. I'm just wondering if anything was going to be done to address the amount of retailers available per section or per area, and also what the licensing, if you're talking a different tiered structure, you're talking at the production level, at the distribution level, and then at the retailer level, what those different costs are going to be for each of those individual licenses, if anything like that has been thought of yet.
So on the cost for each part of the licenses are, I mean, there's a fee, a non-refundable license fee of $1,000.
Yeah, I mean, the fees themselves are relatively inexpensive. There's a $250 application fee, and there's a $1,000 license fee. So very inexpensive for the fees.
What about capping locations? Will OLCC address?
So in the measure, we didn't place any cap on number of licenses, statewide, number of licenses by one person. We didn't place any of those limitations on it. So I think the ball's in Steve's court as to whether he thinks that might be a decent idea.
And that's very similar to what we do for alcohol today, right? We don't have numerical caps, we have qualification-based caps, not caps, process, where we look at, do you meet the standards for license issuance? To the extent, and it hasn't happened since I've been there, where we've actually rejected a licensee based on any other criteria that they didn't qualify for because they didn't pass a criminal background check. Otherwise, it's very rarely that we disqualify a licensee that's coming into a neighborhood that already has other licensees. It can happen. We have some public safety criteria around that, but it does create challenges when we're licensing liquor establishments, and it will certainly create challenges here unless there are other limitations put in place.
Go ahead,
Yeah, I think it's me.
Okay.
I was curious if you know yet if you're going to control production by limiting canopy size the way Washington State did with I-502.
Well, we've had discussions about various ways other states have done it and what we're going to do, but there hasn't been anything close to a determination. The commission hasn't even had a beginning introductory session on this whole issue, so we'll be moving forward soon and thinking about the ways we do it. But we have at a staff level looked at what Colorado, what Washington has done. I think the public process that we have will help us address that canopy size, the size of outdoor grows, the regulations that would go in place in indoor grows, maybe some of the economic complexities and distribution complexities that come in place depending on when local bans occur. It's an interesting dynamic about how that that's going to work and what size of structure do we want to create in Oregon. Is it, say, big marijuana was the term, right? Do we have a policy that encourages that? Do we look to make it smaller scale? I think, I would say this, and maybe I'm wrong, my impression is that Colorado and Washington sort of took the opposite philosophical approach, with Washington looking at more controls that made their operations smaller, more locally based, maybe that's an overgeneralization. But with Colorado certainly being more embracing of the whole economy that surrounds the licensing. So there are several policy issues that the Commission will be decided that will help shape that question, and those are the things that we really want to hear from Oregonians for that.
When it comes to retail sales and off-premise sales, will the retailers be solely for marijuana, or will they be selling other products like liquor or beer or anything else?
Well, the real answer is we don't know. The Commission, we haven't talked to them about how this structure is going to look with the licensing, the privileges around it, but you have to remember that the Cole memo is out there, that we need to protect public safety and be cognizant of both public safety and public health to the extent we have consultations to have. So I guess as the administrator, not the policymaker for the agency, that's as far as I go, but let me tell you, it is a discussion that flows around us as people think about how you start the system, how far do you press the gas. And I think, the Commission has said it was very transparent, very open, measured process to move us from prohibition to a legal enterprise with Oregon. And I think, you're going to have to take some steps along the way that get you there, but you can't go without moderate steps of control along the way.
Hi, thanks for doing this. Questions for the attorneys. I was 2 points of clarification I was looking at. You mentioned that hemp isn't regulated under Measure 91. I was wondering if marijuana byproducts that aren't psychoactive are also regulated or unregulated as a result of that. And my other question was about the travel between legal states with marijuana products. I read in the brochure here that it's technically illegal. I was wondering, how does that work from a legal standpoint? If I live in Oregon, but I'm in Washington with marijuana, can you speak to that a little bit about the legalities or the concerns we should have as cannabis consumers?
Due to federal law, complying with the federal priorities, transporting in and out of states, just cannot be allowed under Measure 91. As time goes along and we see 4, 6, 8 states legalized in 2016, we get a change in federal policy to where maybe there's states' rights to marijuana laws, or of course the ultimate goal, any prohibition federally, that can change over time, but right now importing and exporting out of the state is not allowed. And once again, you'll consult with your own attorney, but any byproduct of marijuana, I think it's considered usable marijuana, so I wouldn't ever try to sell a component of marijuana and say it's psychoactive and say that it's legal to sell it unlicensed.
Yeah, there's a definition of industrial hemp in the statutes, and our definition of marijuana does not, as in the criminal statutes, does not include industrial hemp. So industrial hemp does not equal marijuana. But there's a threshold there in the definition of industrial hemp.
So even byproducts of industrial hemp would be considered marijuana?
Byproducts of industrial hemp? I don't think so.
They are federal.
Sorry, Lee?
They are federal.
Okay. Yeah, I'm talking state law. Yeah.
So, to address the second part which Anthony touched on, I'll just posit this as food for thought and for maybe Steve to think about as well. So, if we are successful in doing what Dave has outlined both in Measure 91 and here tonight, and crafting a regulatory regime coupled together with pricing and taxation that keeps marijuana at retail priced at or below organized black market, what's going to happen in the state of Washington? So let's talk about alcohol real quickly. Washington, quote, deregulated, quote, alcohol, and what happened to their prices? They doubled, right? So citizens from Vancouver don't buy alcohol in Vancouver, right? They come here because they're not stupid, right? So what's going to happen if the Washington regulatory system remains unchanged and the price for marijuana is 2 to 3 times, in some places in Washington, even higher than the organized black market in Washington, and we're selling it across the river for essentially the equivalent of the organized black market. Aren't they going to come over here? Now, as Anthony mentioned, that's all unlawful and violates one of the 8 points of lights in the Cole memo. Are we going to try to proactively do something about that or not? I'm just positing the question. I'm not suggesting, and maybe it's just safer not to answer the question.
I'll add this though. I mean, we were successful in our ballot measure because Washington went first. I mean, if Washington hadn't happened and Colorado hadn't happened, I doubt we would be here right now. We, I think, improved upon their measures, I think. But I suspect that Washington is now going to look at what we did and come to some of those same conclusions and hopefully improve their measures so that their illicit market goes down. So I think that's I mean, there's a dispensary owner in Vancouver who I've met a couple times, and you would think that it'd be the worst thing for his business to have Measure 91 passed, because he can't compete. But he nevertheless was for it. He publicly came out for it because he thought that would spur the Washington legislature to do something. So I think, I think things are going to improve in Washington, and I think maybe the next state who does it might even learn some lessons from us, but maybe do something else better than we do. So it's good. But it shows you the evolution of progress.
My question relates to the business aspect of this industry that's had to operate in the shadows, and what's being done in terms of business outreach, economic development aspects of allowing businesses to be able to invest in this industry. This comes from something that was really shocking to me as an investor. I went to my investment broker at Wells Fargo Bank to see investing some of my portfolio in marijuana-related industries and publicly traded companies. And I was told that as a company policy, Wells Fargo does not allow their brokers to trade in anything to do with the marijuana industry. And with this strategy of trying to bring the industry out of the shadows, to minimize the black market, maximize the legal market, I'm wondering if there's been any thought or actions towards this business education to businesses themselves.
I mean, our law firm has a lot of clients in the industry, and there's other folks who are not in the industry who are thinking about getting in the industry, whether they're landlords or investors or what have you. And banks are about the most conservative entities there are, and the federal government is just behind on this issue, right? I mean, not having banking regulations that work for state businesses is an unfortunate situation. It's another difficulty these businesses have to deal with that no other business has to deal with. And so that's going to end someday. When, I don't know. But if you're asking, there are a lot of folks who are looking at this industry and are looking to get in, and we get questions from, again, folks who are not in the industry. I own a piece of property. What can I do to feel safe? I see this as an opportunity. Should I jump in now? Should I wait and see? And, asking the bank is the wrong person to ask.
I understand that, but I guess my point is that in order to really allow this industry to flourish out of the shadows, there's going to need to be a lot of business infrastructure, including bringing the banks on board because they tend to fuel business development. And also, more specifically, things like the Portland Maritime Commission, the Tourism Bureau, all those different, quasi-government or actual government agencies that can help support the industry interchange at that level?
This would be such a, new burgeoning industry, and I think it's really in its infancy stages. I would encourage everyone interested in the industry to both check out the Oregon Cannabis Industry Association as well as the National Cannabis Industry Association. Congressman Earl Blumenauer has been doing great work to move this issue federally in regards to banking and tax law. Statewide, there may be some things that we can look at. For instance, Colorado passed like a state chartered bank that could potentially do business with the marijuana businesses as early as the first of the year. And so I think there are some ways that maybe the state can move forward on this issue while we wait for the the federal government to move along as well.
I just stopped in here because it's tremendously important, I think, to the OLCC that you get the cash out and then we have a way to actually bank for this industry. It's a public safety issue surrounding it, and while we can't maybe use federally chartered banks, we have to look for a way to, I think, help remove the cash aspect out of the industry. I'd also say at least 3 of my commissioners are business owners. We regulate contract store owners. We'll care in the creation about the system about what your overhead looks like. What are those business costs that we're putting on you as a licensee as you move forward to understand what we do. But first time through, so those are going to be all new things, and we'll see what that looks like.
We've got time for one more question.
In the midst of IPO, we're having the problem of how to bank, how to take money, how to get money to create a marijuana business. In Washington, there are a couple of the credit unions that will bank us, but you have to be a licensee, and we're imbibable, so we're fighting the battle of, being able to produce a product that is acceptable. I would hope, and that a lot of discussion is going to go into the fact of how do you bank these businesses, and how do we deal with the hundreds of thousands or millions of dollars that will be flowing through us. And it would seem the OLCC or someone has got to address it. You don't want somebody walking out of their business with a boatload of cash from the day and become the person to be wrong.
I think the state chartered system that Colorado created it because they felt that the banks who were FDIC insured were just were moving too slow. You wouldn't have to create a state chartered bank for marijuana business if you weren't banking. So there is a bank in Oregon, M-Bank, who is public. They're the first bank to publicly announce that they're taking deposits, and so hopefully others will follow. But yeah, it'd be great if we didn't need a state system because banks
Thank you for coming, and thank you all for